Hello, my name is William Dale. I'm an attorney with the law firm of McChesney Dale in Bowie, Maryland. I'd like to talk a little bit about a question that clients often ask: do I really need a will? A last will and testament is a written document that is signed in accordance with the laws of the state in which it was executed, that sets forth a person's written desire as to how they would like their estate to be distributed upon their death. Most people should have a will. It is not absolutely required because there are provisions in the law that determine how your assets are to be distributed if you don't have a will. So let's start by looking at those provisions. If you don't have a will, there are statutes in most states that are called statutes of intestate succession. Those statutes set forth how your assets are to be distributed in the event you die. For example, let's assume that you have a spouse and minor children. The laws of intestate succession generally would require distribution to your spouse of a certain portion of your assets, and the balance would go to your children. If your children are young, they do not have the ability to handle those assets, and it can end up being a very difficult circumstance. One of the most difficult estates that I have been involved in during my career had to do with a young couple who had 4 children, and the couple was killed in an automobile accident. And the brother of the husband and brother of the wife mutually attempted to handle the assets for the children. The two had to be appointed by the court to handle the assets of the deceased couple. And the two didn't get along, and every expenditure for the children ended up being a court battle, which was very expensive to the estate, and obviously not a very good situation for the children. So if you have minor children, absolutely you need to have a last will and testament, because in your last will and testament, you have the opportunity to name the person or persons who would act as guardians of your children in the event you and your spouse were to die either simultaneously or before your children become adults. You also have the opportunity to name the person who would invest your assets for the benefit of your children, and that person or those persons do not have to be the same individual as is acting as a guardian. So you might have a brother or sister or married couple that would act as guardians, but your father might be more available and interested in helping to invest your assets, and you could name them separately to accomplish those objectives. Obviously, if you have a testamentary distribution intent that is different than what a normal family desire would be, you need a last will and testament so that you can put the rules into that document that would determine how your assets are to be distributed. If you don't, again, your assets would pass by intestate distribution and may not be the same as what you would like to have happen. You may wish, for example, for the distribution of your assets to be deferred until your children are 30 years old or 35 years old, because you want them to have the maturity to be able to handle the assets and not go out immediately and spend them. Or you may have certain family circumstances, such as a disabled child or someone who has special needs, special care requirements. And you can write into your will the appropriate rules and manner in which the individuals who handle the assets will exercise their discretion in order to take care of that loved one. So generally, it's a good idea to have a last will and testament. Certainly if you have considerable assets, it's important to make sure that you have the right to determine how your assets are to be distributed upon your death. But even young couples with young children need to have a last will and testament in place, which they can use to make sure that their desires are accomplished. And remember, a last will and testament is something that you can change at any time. Once you've written a will, You can later write a new will and change the rules and change how you have your assets distributed. It's something that you have available to you, and if you make use of that opportunity, you can rest assured that your desires will be met. Thank you.